Newspaper.
Deputation Lordship. My lord, I beg to mention hearing at number 17, 18 and 19. In view of the
Yes.
order dated 19/11/2025, this analogous appeal may be listed
Yes,
before the appropriate bench.
Appropriate bench?
Yes, order 19/11/2025.
What does it say?
Your lordship also, yes.
Oh, because okay. So the truck driver was strangulated.
Yes.
Okay.
Dead body was found in my colony.
Okay. List this matter before any other bench, not before one of us. Bracket, you write
Lordship, I'm for
Mrs.
appeal.
Miss
Appeal Santam.
Apila Sanktam appears for the
Item number
appellate.
18 and 19.
Doesn't matter.
Obliged Lordships.
Web's notes. Lord's Epic mentioned 1942. Lordship in the amended by Mr. Taliao is not keeping well, Lordship. So his matter can be
42 means 43 also.
refused.
Who's not keeping well?
41.
It starts from
From 41.
41 and 42, yes.
Who is not keeping well? Taliao.
Lordship.
Taliao. Okay, right.
41, 42, and 43.
Yes, what to do? You see, one thing I've noticed, you're putting so many matters on hearing at one go. I mean, there's no point. You should put few and then take it up, finish it up. Anyway, right. On the prayer for adjournment made on behalf of Mr. Taliao, the appellant in WA 2 of 2024, who is apparently not well, lists the matter
After 2 weeks, Lord.
after 2 weeks. Yes, all of them.
Like,
Lordship, I beg to mention item 38. Lordship, I have taken the consent of the.
This is also 38, 39.
But you have not taken the consent of the court.
In fact. If Lordship is pleased to list the matter after 2 weeks.
Why? This is a POXO matter. Section 4.
Lordship.
Yes.
I have no objections.
I have got a problem. We can all read it together. It's a simple matter, no? You're for the state.
Lordship, I'm for the state.
You're for the state, yes. What is the problem with you? I'll hear you.
Lordship. Lordships, I have some personal difficulty with the Lordship. If Lordship may please list the matter after 2 weeks.
And this, okay, what about the 389 application, 430 BNSS? What about that? We can dispose of the IA?
Yes.
If you don't want to finish off the main appeal, at least we can dispose of the IA. Correct? Okay. Yes, so what is the ground for applying for suspension of sentence?
Lordship, actually, on behalf of my age, I'm agent on behalf of not in the case, Lordship.
Where's Mr. Zo?
He'll be coming, Lordship.
He'll be coming. Okay, we'll wait for some time.
Please, my lords. Lordships, on items 23 to 37, these are all read appeals. My Lord Justice Wailong Goma has passed the single bench decision in some of the matters,
Oh,
items 23 to 37.
Otherwise, Lordship, then in that case, your Lordship, item number 32, 33, 34, and 35 can be taken up together. My learned is here, so it can be segregated and can be taken up.
32 to 35 can be segregated, but will the decision in 32 to 35
Yes,
decide the other
Other
matter.
cases, Your Lordship, because these are the leading case, Your Lordship.
But then she had,
No, in 32 to 35, my lord, my ladyship, is not, the
but
one
then,
who
but
might-
then,
Lordship.
similar matters have been decided by her.
Yes.
What issue is this? Landowner?
It's, no, it's
Regularization.
regarding, word charge regularization.
The problem is this. Her 23 to 31 and 32 to 35, the subject matter is the same.
Mm,
Subject matter is the same.
mm.
Now, from 23 to 31, some of the cases have been decided by.
No,
Then?
32 to 35, my lord.
Okay,
my lord has
no,
not-
till 31 has been decided by Madam.
36 and 37, my lord.
36 and 37 has been decided by my sister.
Yes, my lord.
So naturally,
Yes.
so her decision will always be in terms of 36 and 37.
Yes.
She cannot take a different view as in the division bench as has been done. So it will not be proper.
Okay, Lordship.
Though we would have done it. Right. We got 23 to 37, huh? That's right. Adjournment prayer has been made as some of the cases have been decided by one of us. Bracket so and so, huh? Accordingly, leave this matter in a bench without one of us. Then again, my sister's name. Okay.
Otherwise, Your Lordship, if I may submit, item number 23 to 35 are stake appeal, Your Lordship, and 36 and 37 are the private respondent, the petitioner who filed the appeal. So my ladyship must have passed the order in favor of the government.
Correct.
Yes.
So now, what do you think she will do in the appeal? So straight away you have got someone in your favor.
Must
Deeply obliged.
My Your Lordships. Your Lordship, I beg to mention item number 6, Your Lordship.
6.
Yes, Your Lordship. I'm making a mention on behalf of Yanawari for the appellant, Your Lordship. So our leading counsel is in disposal if this matter will be set next week, Your Lordship.
365 days delay.
Lordship, they have stated it's more than 365, but actually it's 456 days. We have filed our objection.
Okay, right. On the prayer for adjournment made by the council by the respondents. List the matter
Applicants,
By the applicant.
by the
applicants, applicants.
No, applicant is whom? You're the applicant.
Yes, Your Lordship.
Item 6.
Item 6, Your Lordship.
Item 6 is Union of India.
Yes,
Yes, oh, yes, Your Lordship.
Huh?
Yes, Your Lordship.
You're the Union of India.
Yes, Your Lordship.
Oh, you're the Union and you're for the private.
private response. All of
Okay. So you have filed an application for condonation of delay.
Yes, Your Lord.
Correct. You have filed a written objection.
objection we have already. filed.
Then
They
what?
file your affidavit.
Huh?
They file your objections.
Then what have you filed? That's all.
No,
You have filed an application.
Your Lordship, my only prayer is that since the leading counsel is in disposal today, so if this matter
Ah,
could be fixed in the presence of the leading counsel, Your Lordship.
Okay, right. Adjournment prayer has been made on behalf of the applicants on the ground that the leading counsel is having some personal difficulty today. On the prayer of the parties, on the prayer of the applicants' counsel, this is the matter. When?
Next week, Your Lord.
Next week.
Oblige.
Mr. Lordships, I beg to mention item 44.
44.
I pray that the matter will be listed after 3 weeks, Your Lordship.
Any objection?
No.
Okay, right. On the prayer for adjournment made on behalf of
Respondent 5.
respondent number 5, which is not objected to by the counsel for the appellant. This is the matter
After 3 weeks
after 3 weeks.
of legislation.
Yes, my lords. Lordship, this is such a lame excuse, but in item 22, I am unable to find the file, my lord, in the chamber.
You're unable to file the file.
Yes, I have requested the PP to allow me to make a photocopy of her.
No, you take my copy. Yeah, it's a section 4,
Yes,
section
my
4
lord,
POCSO Act.
my lord, my lord.
Huh?
Otherwise, I was very much
So-
looking forward to.
No, there's nothing. We can read together the
My
evidence.
lord, my lord.
Not difficult.
My lord, my lord. In that case, my lord.
You're ready, no, Miss Mere? It's a POCSO matter.
Yes.
Yes, my lord.
POCSO matter is very limited
Yes,
in
ma'am.
scope.
Yes, my lord, my lord. My lord.
Only thing we have got to see whether the evidence of the yes, whether Rai Sandeep has been followed or not. That's
My
all.
lord, my lord.
That's
my
all.
lord.
Take it up.
Obliged, my lord.
Please, Your Lordship, I'd like to mention item number 39 hearing.
Item
Item 39.
39.
I pray that this matter may be adjourned for 2 weeks. At the
Why?
meeting, as my senior is out of station.
Who? Who is the senior? Mr. City.
Mr. Yes, Your Lordship.
On the prayer for adjournment made on behalf of Mr. City Jamil, Leonard Kasif for the appellant. List the matter after
2 weeks.
2 weeks.
Obliged, Your Lordship.
May it please your lordship. Your lordship, I beg to mention item number 10, your lordship.
10.
Yes, your lordship, on behalf of Z Khalid, your lordship. Also, if the matter can be listed after 2 weeks, your lordship. Also, here the leading counsel is our station counsel, your
So
lordship.
what? The paper book has been made,
Yes, your lordship.
copy given to you.
No, your lordship, I am not a party in this matter, your lordship.
Acha.
I'm just instructed to mention the matter.
Yes, madam. Yeah, for
I'm for respondent number 2
the
for Mr. Tushiwalong
for the guardian.
for the complainant, Your Lordship.
Respond not to-
Complainant, informant, you mean?
For
Yes.
his mention.
Informant is who? The mother, father?
He was the vice chairman of the village.
Notice has to go to the guardian, usually, or the informant. But since more so to the guardian. Anyway. But this is a section 6 matter. Correct.
Yes, your lordship.
What about the IA?
Lordship, it's for bail, your lordship.
Yes, so why should it be allowed?
Lordship, I don't have a copy, your lordship. If the matter can be listed after 2 weeks, your lordship.
2024, madam.
Yes.
Mr. Counsel,
Yes.
sorry. Huh? Where is Mr. Z Khalid from?
Gauhati, your lordship.
Gauhati.
Yes, your lordship.
So why isn't he here? He knew that the matter has been listed.
Lordship, it is in his post of your lordship. We have taken consent from the opposite party as well, your lordship. That,
You have to take the consent. The final consent is from the court.
Yes, your lordship.
Okay, right. On the prayer for adjournment made on behalf of Mr. Z Khalid, Leonard Counsel for the appellant. List the matter after
2 weeks, your lordship.
4 weeks.
Lordship. Must.
For admission, item number 1.
May I please, Your Lordships? I'm for respondent number 3, Lordships. As per the direction of the order dated 4/12/2025, I was directed to produce one document which directs the states to upload the beneficiaries in the Ushan Tracker app, Lordships. So I have filed my affidavit and also supplied the affidavit to the parties. I may be allowed to read an excerpt for page number 10, Lordships. This was the specific direction being passed in 4/12/2025 order, Lordships.
Just a minute. Page
Lordships.
10.
Page 10, Lordships.
Why this?
File on 9/2/2026, Lordships. 9.
Yeah,
No,
we don't have it,
we
madam.
don't have it. 9/2/20.
9/2/2026, Monday, I filed.
No, it's not here.
It's not there.
You verify with the registry
Lordships,
because it's not in our files.
It's not on record.
Lordships. Not
Okay, right. Miss
Apila Santam Lordship.
Apila Sanktam, learned counsel for the respondent number 3, submits that an affidavit has been filed in terms of the order dated 4/12/2020.
2025.
Full stop. On perusing the records, we do not find any affidavit filed as stated by Miss Apila Sanktam. She is accordingly directed to verify as to why the said affidavit has not been placed in the records.
Lordships.
List the matter on the next day, on the next bench or what? And then in the next bench. This Wednesday,
Next week.
in the next week.
Not. Obviously.
For admission, item number 2.
What is to be done here?
Yes, Your Lordship. Your Lordship, as far as the stretch of road which collapse is concerned, it seems they have given a contract to a consultant to prepare the DPR, and the DPR timeframe is 25th of May 26.
So it's going to be completed by
25th of May.
25th of May.
Just the DPR.
Because, Lordship, I'm appealing for the private response, the contractor. As
Okay.
far as my stretch is concerned, Lordship, that 100-meter that has been collapsed, that is now outside my scope of work,
Outside.
outside, yes. The remaining, I've completed 100%. That 100-meter stretch, that in Pesama, now that is outside my scope. I've already built the road, Lordship, but because of the natural.
So you have not constructed any portion of
I have constructed, but it has collapsed, landslide.
That 100-meter stretch.
100-meter stretch.
that has collapsed.
Yes,
So now
now,
who
that is
is?
outside my scope of work now.
So why is it outside the scope?
No,
Isn't there some clause requiring you to maintain that stretch for some period of time?
No, Lordship, that stretch was given to another contractor
Okay, given to another contractor.
Yes.
After you have finished.
after I finished. Yes. Now the NHDCL has already allotted the work to some other firm, Lordship. In fact, and then they have constructed the existing road, that 100-meter stretch.
Lordship, I'm for the outfitting engineer, not the NHDCL, but I'm overseeing the work executed by the contractor who is supposed to execute the maintenance.
Here for the NHIDCL,
I'm not for the NHDCL.
Authority engineer.
Authority engineer. NHDCL.
authority engineer.
Yes, because the NHDCL, they appoint an authority to overlook the.
Okay, authority appointed by him, but who is going to appoint the contractor who is going to do that? So who have you appointed?
What we have stated here.
You bring your officer tomorrow. You bring him.
What's the offices here, Lord?
Where is he?
So far as the maintenance is concerned, 100% has been completed. I file affidavit on that, my lord.
May I explain, my lord? The contractor was given the work was done, the road collapsed. Now, because of the collapse, it's not just a damage, my lord, the entire road collapsed. So what the NHDCL and the MOTS did is they decided to extend the scope of the contract, acquire more land, and make a new road. So because of that, the DPR, the consultant has been appointed for the DPR. That's where we are right now.
Who has been appointed for the DPR?
Sir, regarding the distinct express, we have appointed the one consultant regarding the KJ project.
Huh?
KJ.
KJ.
Yes, sir.
KJ project.
Yes, sir. And for strengthening of existing roads, sir.
Now, when is he's going to make the DPR?
Yes, sir.
DPR is to be submitted when?
Sir, the timeline is given on the 5th of May. Up to 5th of May, sir.
You see, when is the working season in Nagaland?
Sir, working season is generally, sir, September to October to sir, May. May is the working season, sir.
October to May.
Yes, sir.
When is he supposed to submit the DPR?
Sir, he will submit it, sir, in the May, sir. 5th May, sir.
5th May.
5.
So from 5th May to October, nothing will happen.
Sir, the state is already in the working conditions, sir, in the traffic working conditions. I don't know. We are preparing the sir more strengthening of the existing existing road, sir.
You are strengthening the road that has
Yes, sir.
collapsed.
Sir,
The collapsed portion you are
we
strengthening.
improve the road, sir. We have quality of the road, sir.
Your Lordship, the road which has collapsed, it has been temporarily restored.
Ah.
So the road is pliable.
Okay.
Now, in addition to that, they have expanded the scope of the contract, acquired more land towards the hillside. That is the project for which the DPR consultant is employed. Otherwise, the road is not pliable.
Okay.
The road is restored.
Then if the road is pliable, so let them do it.
Yes, ma'am.
But then one thing is that once the DPR is given,
Sir.
then you have got to then issue advertisements and for that you have got to tender that work.
Yes, sir.
You have to complete it prior to October. You have to complete it. The tender process, everything has to be completed by August.
Sir,
August, September, it should be done.
now road condition is the traffic working conditions at on date, sir. Only 7 location is there is the critical near to Mau Gate, sir. We have separately take up these sections, and that will be completed before the coming monsoon. So that in the raining season, in the monsoon period, road is the working conditions entire. After that, after the submissions of the DPR.
Is the road smooth? Is the road smooth?
Yes, sir.
It should be smooth. There should not be potholes.
No potholes, sir, at present, at all.
Are you verifying?
Sir, only 7 locations. That is the road in the vastly the slip wash. So that will be take up in the month of the March, and we will complete it before the coming monsoon, sir. So that during the monsoon, that road will be smoothly worthy condition, sir.
But let them do it. Right. I heard Mr. Azimomi, learned amicus curiae, and Mr. N. Muzi, learned counsel for? That's point number 13. Mr.
And for respondent number 10, my lord.
So for respondent number 10.
Practice 13 and 14.
Okay. And Mr.
128.
So, huh? That's right. Mr. So what is his name?
R.S. Pante.
Mr. R.S. Pandey, appearing for the NHIDCL, submits that repairing work on the collapsed road has been undertaken. And point number 7.
7 locations. Listing 7 locations. Because those are crucial areas.
And the 7 locations leading to Margate will be repaired without any potholes by March 2026. Correct, by March 2026.
No, sir. The 7 locations up to end of the May, sir.
By May to the rains have started by May.
Sir,
You have to complete by April.
So generally, we start the end of the March, but that will be take some time, sir. Definitely, we will complete it before the coming monsoon. Generally,
Monsoon starts in May in Nagaland.
and generally end of the May, sir. After 15 May, sir.
That is the southwest monsoon you're talking about. But the rain starts in May.
before, sir, that will take 2 months time, sir. We will try to take up the work at
So it take 2 months time. You start from 1st March, you'll end in 30th April,
second week of the month.
second week of March.
Yes.
Then you finish it by second week of May.
Month.
So you complete it by 15 May.
Sir.
Something that will be completed by 15 May 2026. And at the same time, one KJ project have been appointed to make the DPR for an alternative road. Is it for alternative road? Or for
New road.
for making a new road.
For
For making a new road in respect of the collapsed 100 meters roads, which is to be submitted by 5/5/2026. So when do we list it? List the matter after?
So, since 15.
List the matter on 13th March. No, not 13th. You do it on Wednesday, no? You'll have this is the matter on 18 March. On which date the NHIDCL shall inform this court as to whether the work on repairing the road has been undertaken, as has been reflected in this order.
For admission, item number 3.
Yes, Lordship. My sincere apology, Lordship. The affidavit is prepared, but the concerned officer is on leave. So if the matter can come up next week. But as far as the direction of this court is concerned, now we got the rejected claims of the hospitals. Now, apparently what is happening is the insurance company, the Future Janani Insurance, they are negotiating with the hospitals, the private hospitals, without our knowledge. So a direction was issued by this honorable court that there should be no negotiation. Now, Lordship, there have been 2 meetings with the FGI, the Future Janani Insurance Company. Now they have changed the nomenclature. It's now respondent number 5. January Central Insurance Company Limited, respondent number 5. Now, as per the last data that I've submitted before the court, there were a rejection of 2,613 cases without any justification. So I was directed to file an affidavit to that effect. Now, as per the data set I have received from the office, from the State Health Authority, the number has crossed 3,000 plus, Lordship, without justification.
Rejected
claims. Well, Lordship, I have the data with me, but I want to file it in the form of an affidavit, Lordship.
Who's for the insurance company?
He's Mr. 1A Gauhati. He's not here today.
Normally, I hear it online.
It has gone to 3,154 claims, as per the latest data.
We'll call the authority. Yes, insurance. Where they? No one appears. We'll call them.
Because, Lordship, we have written as specific.
Have they got an office here in?
No, Lordship.
Where are they located?
Their office is based in Mumbai.
Mumbai.
Yes.
They must be having a regional office somewhere.
Lordship, very interestingly, they don't have an office, even in Ireland also. Lordship, if the personal appearance may be called for, Lordship, because they cannot play hide and seek with us, Lordship. We have paid the premium to them, 100%, Lordship. 100% premium we have already paid to them. Now they are rejecting the claim of the hospitals on one pretext or other. Now, Lordship, the rejected claim is 3,514. Now, pending claims, Lordship. Pending claims is coming to
3,114 or 54. Which one? Make up your mind. Is it 154 or 114?
Lordship, yes, 154, Lordship. 154. Rejected claim. Now, the pending claim is, Lordship, 2,226.
You said rejected claim is 3,154.
3,154. and pending claims. Besides the rejected,
Pending claim is how much?
2,226. And the amount is coming to 17 crore 54 lakhs 19,994. The latest. Now the claim of the insurance company is that they are unable to track their claims because the State Health Authority portal and the National Health Authority portal are linked. And they are aware of the fact. They are aware of the fact, Lordship. And that has been already
So
observed.
this insurance company is respondent number?
5.
Who is for the petitioner? Right. Okay, anyway, right. This is a matter regarding the healthcare scheme. And the non-payment of the bills of the patients by the respondent number 5. Correct?
To payments of the claims of the hospitals.
Correct.
Yes.
Payment of the bills by the respondent number 5 to the concerned hospitals.
And panel hospitals.
Concerned hospitals. Full stop. Mr. N. Mozui appearing for the respondent number
6.
6. Submit.
Okay.
4. Submit that as on date, the insurance company, that is respondent number 5, has rejected 3154 claims of patients, of hospitals in respect of the healthcare scheme. Further, full stop. Further, there are 2226 pending bills as on date. Ms. Patel. No one appears for the insurance company, that is the respondent number 5. This state of affairs cannot be allowed to continue unchecked. We are of the view that the respondent number 5 would have to give reasons by the next week as to why the claims made by the concerned hospitals have not been paid by the respondent number 5. Next para. The respondent number 5. No, full stop. But you have to, your affidavit is not here, no.
I'll be filing within a week, Lordship.
You file your affidavit, others, what will they answer?
Yes, Lordship, yes. Because it's already prepared.
Right, next, Mr. N. Mazui submits that he will be filing an affidavit within
3 days, Lordship.
within 3 days regarding the rejected claims and the pending claims,
Lordship.
which the insurance company will have to answer within 1 week thereafter,
Lordship.
or 10 days thereafter. Failing which, the officials of the respondent number 5 may be called for.
Lordship.
List the matter on, today is 11th. List the matter on 25.
Obliged.
Or list the matter on 18th.
18.
Week to week, call them.
For admission, item number 4.
Yes.
Yes, Lordship. Here, notice has been received on behalf of all
I'm
respondents.
yet to receive an instruction. So 3 weeks time will be granted, sir.
Lordship, here on the last occasion, instruction was given that the government may ensure to file affidavit, counter affidavit, and the interim was to consider on the next reasonable day. So my interim is yet to be considered as of now.
Yes,
Lordship, here now the petitioner, they are trying to restore the notification 1977. But that notification is already superseded by the notification September 2025.
that is what they want to say.
Yes, and the similar matter is also pending, the same ICC matter. So I
What is pending in which case?
WPC 72 of 2025.
In that case, Lordship, there is a stay, and therefore the government has
If
put
there is a
partial
stay, so that stay will apply here.
Yes.
No, partial stay only, Lordship.
Partial
Only
stay.
with respect to four indigenous, that is the Kuki, Kachars, Mikirs, and Karos, not the Nagas. There are 5 indigenous as per the first draft to 1963 indigenous inhabitant of Nagaland. So only the 4 parties have.
Who is the fifth? Who is the fifth?
It's me, Naga. That is the present petitioner
Now,
on behalf
yes.
of the Naga
Present
indigenous.
petition is filed by the indigenous inhabitant of the state of Nagaland. This petition.
So,
That you want to resort to the notification 1977.
No, we are only seeking for the state to implement.
where is the order passed in 72 of 2025? In the other writ petition,
Yes, Lord.
where is the order passed in the other writ petition staying this notification?
Staying the notification dated 29.
Where is the order?
That order I do not have as of.
Please have it, for we don't know.
That is 8.
Unfortunately, my phone is there. So you have to send me by WhatsApp. Then I'll have to go to my chamber, take out my phone, read it.
Pardon, Lordship. I do not have the order as of. I will supply.
You should supply. That's it. Otherwise we don't have all the documents like you have.
Worship, we may be allowed to file the affidavit, but I need some more time to update this.
But you please file. You cannot
Yes.
adjourn. On grounds which are not germane.
Your Lordship, problem is instruction.
Then we'll stay. If no instruction, we'll stay.
We may be allowed to file the affidavit.
Okay, we'll give you one chance.
Lordship, if the enumeration, as per the order dated 29/2024, enumeration list has to be carried out by the government.
So basically, your
That
case
is
is
carried
that
out, then
your
filing
basic
of this
case is
PRS
that
of infractions.
the recommendation of the RIN has not been adhered to. That's all. RIAIN.
Yes.
That's your case. And we will see. Let them file their affidavit, but then the problem if they don't file, then then why not stay? If stay has been given in the other case.
That stay is only in operation with respect to the 4 tribes.
We know,
Lordship.
that's
Partial
why-
stay.
Anyway, right. The Mr. C.T. Jamil.
Lordship,
No.
I'm Ali Bozgu.
Huh?
Ali Bozgu.
Oh, yeah, Mr. Aliba Ozukum, sorry. Appears for the petitioner. Mr. Imtim Song, learned additional AG, prays for a further
3 weeks.
3 weeks time to file affidavit. Full stop. No, the prayer is allowed, just here. Mr. Aliba Ozukum submits that in a similar matter, that is WPC 72 of 2023, 72 of 2025, stay has been granted. Stay has been partially granted in respect of the impugned order dated 20/09/2022.
Lordship. As well as the cabinet decision.
As well as the cabinet decision. Full stop. However, the stay does not relate to the present petitioners. Present petitioner. This is the matter. This is the matter on. Give a date after 3 weeks. The prayer of the interim prayer of the petitioner may be considered on the next day if no affidavit is filed by the state. Next, you're right. The matter pertains to the grant of indigenous inhabited status without adhering to the recommendations made by the NIIT.
No,
RIIN.
yes,
RIIN.
by the Bano committee report.
By the Bano committee. That's all. This is the matter also. Which Bano? The Chief Secretary Bano?
Yes, the retired former chief secretary.
Wife of Zopianga.
Doctor.
The daughter of Zopianga. And Zopianga is, he's not a Mizo, huh? He's a Naga. Born in Mizoram. So Zo means Mizo, Pianga means born. So he is born in Mizoram. He's a Naga, but born, he's got a Mizo name.
For admission, item number 5.
May I please, Your Lordship? I I pray this matter may be adjourned for next week.
Why?
As the leading counsel, my senior is out of station. Sir City General.
There's what to do. Pleadings are complete? No, there's no, this is a writ appeal. Right? So you have filed, this is a fabricated B.Ed degree, no?
Yes.
Then
Yes.
what remains?
As the council, senior council for the land is absent, Lordship. Maybe we fix next week on 18, Lordship.
Okay, on the prayer for adjournment made on behalf of Mr. C.T. Jabir, who is
Out of station.
out of station, this is the matter in the next week.
Interim, Your Lordship. There's an interim.
Interim order to continue to the next date.
For admission, item number 7.
No adjournment.
Lordship, but I have served notice to respondent 2 by Dusty,
Oh, very good.
and I filed my affidavit also. But they are not-
What is the matter all about, madam? What is the matter all about?
This is for non-furnishing of information sought by way of RTI. So,
So what remains now?
so Lordship, in the writ petition, it was disposed of with direction to furnish me the new committee report. However, in my RTI application, I had only sought for the earlier committee report, which was submitted in April of 2020.
But the earlier committee report was not accepted by the government.
Lordship, however,
What right do you have to be furnished a committee report which has not been accepted by the government?
Lordship, that is on.
That is the issue.
Yes.
That is the main issue. Now a new committee report is to be made and that is to be given to you, correct?
Lordship.
Has the new committee report been made?
No, Lordship.
So once it is made, it will be given to you, provided that is also accepted by the government. If the earlier report is not accepted, what right do you have to be given?
Lordship, however, when till the time of my second appeal to the NIC, this earlier committee report was in force, and it was the order of the NIC which directed the respondents to furnish me the earlier committee report.
And the NIC said that after 3 months,
Yes.
it changed.
Yes.
But to give you the same committee report, correct?
Yes, Lordship. However, they have totally disregarded the order of
NIC
the
report.
NIC, and they have quashed the earlier committee report to nullify the order of the NIC, Lordship.
Oh.
So that is my case. However,
Yes,
there's a-
madam.
Your Lordship has rightly noted that the first committee report, in that first committee report, there was anomaly. So, and it is unofficial. So the information sought under RTI could not be furnished since it is unofficial.
Why?
And Your Lordship, till the government approve.
Where does it say that till the government approves, it cannot be
We have
given?
filed our affidavit, and in the affidavit, we have clearly stated that the committee report is. There was.
Where is your affidavit?
Affidavit page 89. Page 89 is our affidavit. Paragraph 4.
Acha, this is a writ appeal, no? I
Read
forgot.
appeal, yes, read appeal.
Okay, page 89. Oh, this is a limit. Oh, sorry, wait. We cannot go into the
Yes.
merits. There is a limit, there is a condonation of limitation. Okay, application, okay. How many days?
30 days, Lordship.
Any objection? No objection, right. This is a right heard, Miss
Upang nila, Lordship.
Learned counsel for the applicant. You submit that there is a delay of 30 days in filing the appeal. Miss S. Mere.
Lordship.
I remember because I think I came to your wedding, no? Kohima wedding. Long time back. Miss S. Mere, learned government advocate, submits that she has got no objection to the delay being pending. In view of the reasons given in the application for condoning the delay, besides taking note of the submission made by the learned counsel for the applicant, respondents, the delay of 30 days is condoned.
Lordship,
I is accordingly disposed of. Then in the main appeal. Yes.
respondent 2 is not represented, so if notice may be issued in the writ appeal, Lordship.
How does it help you? What are they going to say?
Lordship, the NIC is, since they are a party, may not
Her
be a,
grievances is mainly against the NIC, the decision of the NIC, the findings of the NIC.
yes, Lordship, their order is. So
No, it's not against. She wants the NIC order to be followed.
No, Your Lordship.
Lordship, my grievances is against the state, but I have also impugned their order, the modification of their order.
Who NIC order?
NIC's
But
modification.
NIC order by a flux of time. I mean, that 3 months period has gone, finished. So you cannot have a grievance against them.
Lordship, however, since they are a party.
Okay.
on the writ.
Okay. Heard Ms. Swenson, learned counsel for the appellant. Issue notice returnable in. Wait, before that, heard Swenson, counsel for the part. The appellant is aggrieved with the impugned order of the learned single judge. Wherein it has directed that only the new, what is that, recommendation?
Committee report.
New committee report, which is to be made within 3 months, should be furnished to the appellant. While the appellant has paid for being furnished a copy of the old committee report, which has not been accepted by the government.
Lordship, that point is also contentious. Accepting by the government, except
Which
for a
has,
blank- except for a blank statement by the government that it has not been accepted officially.
So
There's
that you decide.
Lordship.
That is the stand which has allegedly not been accepted by the government.
Gotcha.
Allegedly. Issue notice returnable in 4 weeks. Ms. S. Mere accepts notice on behalf of
Respondent 1, 3, 4, and 5.
1, 3, 4, and 5. Appellant to take steps for service of notice upon the respondent number 2 by speed post,
By Dusty, Lordship.
by dusty service
Lordship.
within 2
3
weeks.
days.
Within
3 days.
Within 3 days. List the matter after 2 weeks.
Lordship. I'd like.
For admission, item number 8.
Good morning, my lord.
Yes.
My lord, this is an appeal passed by the single judge, my lord, on 4/12/2025, my lord,
Yes.
against the my lord in the first page, my lord. The imprint part, my lord, is available at page number. Page number Roman 10 in the previous
Page Roman 10. Page Roman.
yes, page Roman 10. Right.
The certified copy of the judgment.
Yes, ma'am.
Huh?
Yes, ma'am. Pair number 17, ma'am.
Page Roman 10.
There's no.
There's no Roman 10 in my copy.
Then in that case, my lord, it must be there in the inside the imprint judgment also, my lord. Yes.
But it will not be Roman 10, no.
No, my lord, page 23, my lord. Page 23 is the, my lord. Page 23, my lord. Okay. 23, my lord.
Yes.
And last page, my lord, period number 17, my lord, will come to page number 17 will come to page number 32, my lord, of the memo of appeal.
Yes.
Page number 17, my lord. May I read, my lord?
Yes,
in view of the aforesaid discussion and the case laws which have been relied upon, this court is of the opinion that imprint action of the encasing the bank guarantees by the communications dated 5/8/21 and the 6/8/21 is unsustainable in law and is accordingly set aside. It is, however, made clear that the present interference is only on the aspect of violation of the principles of natural justice, and if at all the corporation is to make any recovery, it has to be done strictly by following the process of law and by giving adequate opportunity to the petitioner to make its representation. Such action has to be supported by properly worked out calculation as to how the amount of rupees 40,27,369 has been arrived at. In other words, the process has to be fair and transparent, which is the hallmark of the mandate enshrined in the Article 14 of the Constitution of India. Consequently, it is directed that amount contained in the bank guarantees, which are the subject matter of the communication dated 5/8/21 and the 6/8/21, are to be refunded to the petitioner within a period of 45 days from today. So, my lord, learned single judges have opined that the action taken is illegal. That is, however, the amount which is to be recovered is 40,27,369. But out of which, my lord, the honorable single bench, my lord, is only giving the amount of 25,51,700 only. And there is a difference of 14,75,669.
Mr. Counsel, there is a difference.
Yes, ma'am.
In, you see, the issue. The issue is that the amount that is payable by you to them, whether it's, I'm not on the issue of whether it's right or wrong. I'm on the issue of the calculation.
Yes, ma'am.
Said that 40 lakhs have to be given by you to them. Correct?
Yeah, that was the, I mean.
Correct. Now,
yes.
How much your bank guarantee, the two of them, what was the value of the two bank guarantees?
Two bank guarantees is one is 25 lakhs, 51,000. 25 lakhs, 51,700.
700 and
21 altogether 25 lakhs, 51,700.
Correct. So they encash the two bank guarantees.
Yes, two bank guarantees.
So that amount has to be given back to you.
Yeah, that is correct, but here's the
lawsuit. Now, how do you say that they still owe you 14 lakhs? Why? On what is the basis?
Total money, my lord, which they have recovered is, my lord, 40 lakhs, my lord.
No, from where do you get that? That is wrong. There's nowhere stated by the single bench that for 40 lakhs have been recovered. From where did they recover 40 lakhs?
No, my lord, that is why, my lord, the honorable single bench, my lord, have
No, you tell us.
Yes, my lord.
How did you give 40 lakhs? For 25 lakhs is by way of 2 BGs. How did
Yes,
you
2 BG.
how did you give the remaining 14 lakhs?
My lord, I just coming up to the.
Yeah, I think you're not aware of the facts.
No, my lord, I'm just coming, my lord. Because 40 lakhs is total amount which have
Total
been
lakhs is what
deducted.
you are supposed to pay. But they have recovered only the amount mentioned in the 2 BGs. The 2
Not only
BGs
BG, my lord,
paid back.
because they have deducted this particular amount from the bank, from my bank account, bank.
No, no, no. Show me where have you said that. How can they deduct from your bank account?
Yes, my lord.
I
That
think
is
you're
just,
right.
I'm just showing, my lord. I'm just
Yeah,
showing.
Vishwas,
I'm just showing, my lord. You know.
I think you're leading us up the wrong garden.
My lord, I'm just showing PS 166, my lord. PS 166, may kindly see for a minute, sir. PS 166, my lord.
166, yes.
Yes, this is the calculated amount, my lord. Total area, my lord.
Correct.
This is
This is
the.
what they say that you should pay. It doesn't mean that they've recovered this amount. Show us how they've recovered this 40 lakhs.
Yes, my lord.
How not recovered, how they've taken 40 lakhs from you. You see the SD, the security deposit that you made of around 30 lakhs has been returned to you. That's all.
No, yes,
And 2
security
BGs.
deposit, because 30 lakhs, that has been again total altogether 40
No
lakhs.
case, no case, Mr. Counsel.
No, my lord. My lord, just I may be permitted, my lord, because this is the amount which they have deducted, my lord, from my account, my lord. 40 lakhs, 27,300.
Where have you said that they've deducted from your account? Where have you said in your appeal or in
Yes,
your
my lord.
petition? Where have you said?
I'm just finding, my lord. I'm just finding.
Yes, you find it first, fast, before we dismiss your case.
Yes, my lord. Appeal of payment.
You're selected.
I
I will not. I cannot do. So you have to withdraw. You withdrew. And then unfortunately, that's this bank. Now what you have to do is bank guarantee.
I'll let Michael come back with the proper instruction. I'll come back with proper instruction.
Even they don't
Guarantee for single bench. They could not have been. They should have given you notice. And then so return it back. So they return this back to the fact that no. He's saying that they are still to give 14 lakhs. Where 40, that's what you make them say, no case.
Yes, my lord. May kindly see pillar number 10, pillar page 9. Memo of appeal, my lord.
Yes.
My lord, pillar number 10, my lord.
Yes.
Page 9, my lord.
Yes. Read.
That despite the matter having thus attained finality, the respondents by communication dated 16/7/2021, 22/7/21, and the 3/8/21 unilaterally imposed a fresh and a composite alleged liability of 40 lakhs 27,369 upon the appellant, purportedly towards retendering post litigation expenses, departmental PADA, and so-called second penalty, and recovery of security deposit already refunded. The amount of rupees 40 lakhs was arbitrarily broken down as follows: publication of the 4 fresh NITs, litigation expenses.
Mr. Counsel, it's like this.
Yes, ma'am.
It's like this. It's like supposing I am asking you.
Yes, ma'am.
For 100 rupees.
Yes, ma'am.
And I have taken 80 rupees of yours from Mr. B. From one Mr. B, I have taken 80 rupees. Your money.
Yes, ma'am. Yes, ma'am.
And I have returned that 80 rupees.
Yes, ma'am.
That does not mean that I have taken 100 rupees.
I will take the time some more.
My lord, may I take proper instruction, my lord? Can you
No proper instruction. We're dismissing your case.
No, my lord, just one day, my
lord. No case. You can go to Supreme Court. You can go to Supreme Court. No case.
Only for one day, my lord.
It's very thick file you have made and no case at all.
No, my lord, I'm just seeking only 1 day.
Why shouldn't we impose cost upon you?
No, my lord, only
Wasting
just
our
I'm
time.
seeking only 1 day, my lord. 1 day, my lord. 1 day only, my lord. 1 day, just let me take instruction from the from my this thing.
You've got no case at all.
Any 1 day, my lord. I'm just seeking only 1 day.
Okay, wait. We'll just write down whatever we know about it. Then we'll take it up tomorrow, and even if you don't, and we'll dispose it of.
Yes, no problem, man. No problem.
Right. Heard, Mister?
Enzo Tendro.
Huh?
Enzo Tendro, senior advocate. And my junior is there, Mr. Medo is there.
Tendro, the Singh, learned senior counsel, assisted by Mr.
Medo is here, Medo.
The appellant has put to challenge the judgment dated 4/12/2025. Judgment and order dated 4/12/2025, passed by the learned single judge in WPC 231/2024. Where is it? It has held that the action of the Respondent Food Corporation of India, bracket FCI, in encashing the two bank guarantees amounting to rupees 25,51,700 was unsustainable in law. It also held that the interference by the learned single judge had only been made in view of violation of the principles of natural justice. And if at all the corporation, the FCI, was to make any recovery from the appellant, it had to be done strictly by following due process, by giving adequate opportunity to the appellant to make his representation against the loss made by FCI on account of the appellant having withdrawn from the tender process in which he had been selected. The case of the petitioner, the appellant's counsel submits that the learned single judge failed to grant complete and consequential relief by not directing refund of the entire illegal recovered amount of rupees 40,27,369 and only limiting the refund to the two bank guarantee amount totaling 25,51,700. He submits that a balance sum of rupees 14,75,669 is still to be paid by the FCI to the appellant. Full stop. Next paragraph. The facts of the case, as can be seen from the pleadings that are before us, is that the appellant had participated in the notice inviting tender, bracket NIT, number 1 of 2019, dated 24/1/2019. The petitioner's bid was accepted by the FCI, and the same was communicated to him on 29/3/2019. The petitioner deposited 50% of the security deposit amounting to rupees 30,61,703. Full stop. However, the petitioner subsequently submitted a representation on 2011/2019 for refund of the security deposit and express its inability to perform the contract work in question. Full stop. As no action was taken by the FCI, the appellant filed WPC 226/2019, which was disposed of by order dated 22/11/19, directing the FCI to consider the representation of the appellant. The FCI, the FCI thereafter considered the representation of the appellant and approved refund of the security deposit of rupees 30,61,703. Full stop. The appellant was blacklisted for 5 years with forfeiture of earnest money deposit. The challenge made to the blacklisting of the appellant by the FCI was dismissed by this court and the Honorable Supreme Court. In SLP bracket civil diary number 23129/2022, white order dated 26/8/2022. So, sir, the work in question was retendered and work allotted to a third party by the FCI. Next para. The FCI thereafter made an assessment of the loss suffered by it due to the withdrawal of the appellant from the contract work provided in the NIT number 1 of 2019. And the same was assessed to be as follows. Take it at page para 12 of the impugned judgment. There's a chart. Next para. Pursuant to the assessment made by the FCI regarding the loss suffered by it due to the withdrawal of the appellant from the tender process, the two bank guarantees amounting to 10,54,200 and rupees 14,97,500, totaling rupees 25,51,700 were encashed by the FCI from UCO Bank. Full stop. Next para. The appellant thereafter put to challenge the encashment of the two bank guarantees by way of WPC 231 of 2024. Okay, what have I said? Full stop. As stated earlier, WPC 1231 of 2024 was disposed of by the impugned judgment and order dated 4/12/2025. In terms of para 17 and 18, as which are reproduced herein below as follows. Next. The amount of 40, the rupees 40,27,369 is the SS amount made by the FCI to be recovered from the appellant on account of the loss suffered by due to the appellant withdrawing from the contract work in question in relation to the NIT number 1 of 2019. As the security deposit amount of rupees 30,61,703 has already been returned. It is not understood as to how it has already been returned, and the BG amount, the encashment of the two BGs amounting to rupees 25,51,700 has also been directed to be returned. It is not understood as to how the FCI is still liable to pay to the appellant rupees 14,97,500. Next para, the counsel for the appellant submits that he would like to obtain instructions and the matter may be listed tomorrow. On the prayer of the appellant's counsel, list the matter tomorrow.
For others, item number 9.
Right, madam.
Lordship, Your Lordship, the petitioner is seeking for retirement benefits, Your Lordship, for the service done by his late father.
Did your father file any case? No.
Lordship, no.
Then what is how
It
can
was
you
only
claim?
after the death of the deceased that the son in the
When did your father die? When did your father retire?
Lordship, my father expired on 17th of July 2018 after serving for 24 years.
17 July of 2018.
Lordship.
He died in harness.
Lordship.
Died in harness. He was working as
LDA under the Department of Horticulture, Mon.
LDA.
Lordship.
As what? LDA as work charge. What as
He was appointed as work charge, but then at the time of his death, he was a casual employee. He was reverted.
Yeah, he died as a casual employee.
Lordship.
Fixed pay.
Fixed, Lordship.
So he initially joined when?
On 14/9/1993.
1993 as what?
As work charge LDA on ad hoc basis. Firstly, as ad hoc
Work charge
basis.
LDA.
Lordship, first appointment as on ad hoc basis. And then while giving extension, he was converted to work charge, Lordship.
So he worked for 25 years.
Lordship.
Is it?
Yes, Lordship.
He did not file any case for regularization.
No, Lordship, never.
Then?
Only after the date, Lordship.
When did you file?
My representation, Your Lordship, I filed on.
When did you file the writ petition?
Writ petition was filed on 30 October 2020.
Filed by you?
Lordship.
Okay, so what did the single bench say?
I'll take you to Lordship page 18 of my review. The relevant part.
This is a review petition.
Lordship, yes, Lordship. Lordship, earlier in the DBG page, it was before Honorable Justice S. Soto and Honorable Justice Gesima. And then Lordship, owing to retirement, Lordship was.
Let us see the division bench judgment.
The division bench judgment.
Page 38.
Lordship. Relevant part, Your Lordship, page 43. Paragraph 8, may I read, Your Lordship?
Yes, paragraph 8.
Lordship. May I continue, Lordship?
Yes.
8. Further, we agree with the submission of Mr. Such and such, Learned Counsel for the appellants that though the OM dated 17/3/2015 provided the scheme for regularizing absorption of both work charge and casual employees, the respondent's husband was not eligible for consideration for regularization of his service since he did not serve for 30 years continuously as required under the OM. Because admittedly, the respondent's husband, when he died, the length of his service was only 24 years plus, and he did not enjoy scale of pay. This was the.
So there is a provision for regularization as per the OM.
Lordship.
Now, if you do not have the requisite
Lordship, in my
length of service, then how are we going to regularize you?
Lordship, in my writ petition, Your Lordship, I didn't seek for regularization on the basis of the OM 2015, Your Lordship. And then, while I was in service, OM 2024 was covering the field, but then again, I was reverted back to casual, Your Lordship. None of the office memorandum covers me, Your Lordship. And then, regarding this notification of office memorandum, Your Lordship, is I can place adjustment before this honorable court, Your Lordship.
Regarding? No, how will that help? This is you see, a review can be filed only on certain
Lordship.
grounds. So under which ground do you come in?
Lordship, here, prior to my date in service, Your Lordship, my father's, Your Lordship, one employee who was junior to me, he was given regularization, Your Lordship.
That is not a review. That is not a ground for review.
Lordship, when this is a discriminatory, Your Lordship. Article 14 is to be followed, Your Lordship.
Mr. Counsel, this is a review.
Yes, Lordship.
You have to you see for order 47 has to be looked into whether you come into any of the conditions provided therein for a review of the order.
Lordship.
A review cannot be just because of some other. A review cannot be an appeal in disguise.
Yes, Lordship.
That is what you do. You go to the Supreme Court. If you think that the decision of the division bench is wrong, then you go to the Supreme Court. You cannot say that they did not consider the judgment or they did not consider the review, the issue of this similar employee being regularized. Did you take up that matter before the division bench that the similar person had been regularized? You took it up.
Yes, Lordship.
You took it up and still they did this. Then where is the question of review?
But then, Your Lordship, if I may, Your Lordship, this the appellate court was of the impression that I was covered by the 2015 office memorandum, Your Lordship.
You see, a review is not an appeal in disguise, Mr. Counsel.
Lordship,
You go there. Either I dismiss or you withdraw. and you go to the Supreme Court.
Then Lordship, at this stage, I'm allowed to withdraw.
Better. You go. Heard Mr. Learned counsel for the review petition, who submits that he would like to withdraw the review petition. Mr. Mr. Moin Chin, you're the additional AG?
No,
Uh,
senior government.
Senior government counsel,
Or respondent number 1 in 3.
respondent number 1, 3, and Mr. Mojabi for 2 and 4 are present. The pair of the review petitions counsel is allowed, review petition dismissed as withdrawn.
Obliged, Lordship.
You see, there are judgments, even for review. There was this matter recently with regard to income tax, not even regard to tax, where a petition, where a proceeding before the income tax authorities and before the High Court was closed due to a decision made by the Supreme Court. Now, in that same case, the Supreme Court review its order, and accordingly, the person who had lost because of the closure of the case said that because of the review made by the Supreme Court in that case, the same case, so the review should be allowed in the High Court. But there are decisions of the Supreme Court which says that even if a subsequent decision is made by the Supreme Court, that will not affect the decision already made in the High Court. It's slightly confusing, I know, because the Supreme Court also there was conflicting decisions in this aspect. So in your case, though, there is no review as such. You are just wanting to.
Certain conditions.
Yeah,
for
that the order 47 or 50.
material, and all those things.
Obliged.
For orders, item number 11.
Yes.
Your Lordship, the service upon respondent number 4 and 5 is not yet completed.
That doesn't matter. You give your case.
The leading counsel in this case is out of station, so maybe the matter may be adjourned for next week, perhaps.
You have given a fabricated document.
Not actually.
Yes, it is fabricated according to the authorities. According to you, it's not.
It is.
According to the authority, it is fake. Now, whether this court, as a writ court, can we decide disputed questions of fact?
No, Your Lordship.
Can we take evidence?
No, Your Lordship.
So, you see, another thing you have said is that the B.Ed degree, I think, was not a basic qualification, but only a preferential qualification.
Yes, Your Lord.
But that does not take away the fact that you are supposed to provide correct documents. Once you provide fake document, your case goes.
But Your Lordship, it's not a fake document.
How will I decide? Because we'll say who is more handsome or who's more prettier. Then he will win hands down. We have to see who's taller, who's thinner. We cannot decide on that, no?
Yes, sir.
And what to do, Mr. Hangami? We were thinking of disposing, but because there's no, we don't find any. You see, just because a document has been asked for, which may be for preferential reasons and not be a basic qualification, does not mean that those preferential documents can be a fake document. It has to be genuine. So, according to you, that is not a fake document.
Yes, Lordship.
But then how are we to decide that?
Exactly, Lordship, but the ground before in the writ petition was that it has to be limited to whether there was natural justice has prevailed or not.
No.
So it was not according to the judgment. Also, the learned single judges observed that there were not the natural justice has not been observed.
Okay, but then you see, natural justice is not a sine qua non for all cases. You see, natural justice will depend upon if some prejudice is caused to you without following the principles of natural justice. Now, supposing there is a decision with regard to whether 2 plus 2 is equal to 4 or 5. And if the answer is going to be 4 anyway, even if we give notice to you, then no prejudice can be said to be caused to you. Okay. But if the answer can be, might be 11, might be 12, or something like that, then we can say prejudice has been caused to you because it could be either 11 or 12. But when the answer to that question is going to be, there's going to be no change, then you cannot say that some prejudice has been caused to you. But anyway, it's Mr. Jamil not. Right. A general prayer has been made on behalf of Mr. Siti Jamil. And another thing, you have taken a ground that in another case, there is a similar, but that case is different.
It's similar, Your
It is not similar.
It is similar.
It is not similar. Go to page 40. I think it's page 40. Yes. Come to page para 27, the last sentence, the fourth line. However, it appears there is no material in the inquiry report to show that the said B.Ed certificate was fake. So there was no material in that case to show that the B.Ed certificate was fake. But out here there appears to be some material. There's a difference. You cannot put, everyone cannot wear the same jacket. Some are big, some are small. You cannot paint everyone with the same brush. Anyway, right. Adjournment prayer has been made on behalf of Mr. Siti Jamil, Learned Senior Counsel for the appellant.
This is the interim, Your Lordship.
The appellant herein has been removed from service on the ground that she had submitted a fake B.Ed certificate. The respondent's case, on the other hand, is that the respondent's case, on the other hand, amongst other grounds, is that B.Ed certificate is not a basic qualification required for appointment to the post of graduate teacher, but only a preferential condition. As such, no prejudice can be said to be caused to the respondents on that score. List the matter after
A week.
a week.
Your Lordship, there's an interim order.
Interim order to continue to. You see, madam, you should tell us beforehand. Otherwise, we read and we come. We waste a lot of time. I could have been watching Netflix.
I apologize, Your Lordship. Obliged, Your Lordship.
For orders, item numbers 12 and 13.
My please, Your Lordship. Your Lordship, as per the last direction, I'm supposed to bring the report by the medical board. However, last Thursday, Your Lordship, when I contacted Your Lordship, the chairman of the medical board was out of station. So they are going to constitute tomorrow again. So they will give the report. So next week.
Operation Goldstone. Miss Livika. Additional PP.
It's designated as PDP.
PP, oh, you're PP now. Oh, wow.
They're all
Oh, yeah, oh, PP. How many PP?
There's no additional.
Oh, there's no additional PP. Miss Livika PP submits that she needs time, as the medical board is going to is going to examine the petitioner,
Your
the applicant, when?
No, Your Lordship, actually, the medical court has already given an observation
Oh,
that
oh.
he has to go outside
Then,
the
then,
thing. Now, what the direction of the court was that post-surgery, how many, because now he's already.
that will depend upon the doctor.
Yes, that's
Who
what.
are we to
That
decide?
was a specific.
So let him be operated
Yes.
first, no? Let him be operated first. Let the doctor give his report. You cannot expect them to straight away come. So you see, we cannot decide now.
That's true.
Complications can arise, anything can happen.
That's true.
It depends upon what type of operation is going to be conducted. Whether you're going to smash the gallstones with the sound waves.
It's going to be through laparoscopy. Your Lordship.
Okay.
However, the care and attention that is need to be the.
So let the doctors say we'll give a minimum amount of things. Let the minimum- Under custody. No, we can give bail. Because we can give interim bail. We can grant the interim bail. No, it's only for, because this is only for the purpose of surgery, nothing else. The question of granting suspension only on that ground may not be proper, depending if it's very serious. For that, you can file a separate application, if required. We say that no bar to filing a separate, but we say that the suspension is limited for a certain period of time, for maybe, I don't know, 3 weeks, or for a month, and so bail will be granted for a month only. And if and thereafter will if because there's no ground, it's section 6. Section 6, correct? And I mean, it's quite apparent that you have done it. It's apparent that you have done it. So we'll give you a limited suspension of sentence only due to medical ground. And on the completion of that period, you've got to go back in.
Yes.
That's all.
So Your Lordship.
Okay, right. Heard Mr.
James,
Learned counsel for the applicant. Also heard Ms. Livika, learned PP. This is an application under section 430. 430 BNSS for grant of, for suspension of the sentence to be undergone by the applicant/appellant pursuant to the impugned judgment and order dated 26/9/2024, passed by the Fast Track Special Court, Dimapur, Nagaland, in GR case number 354/2019, bracket WNPS. This is PS, arising out of WNPS case number 40 of 2019, by which the applicant has been convicted under section 6 of the POCSO Act and sentenced to undergo rigorous imprisonment for 38 years. With a fine of rupees. How much? Oh, no fine.
No fine.
38 years. That's all. 38 years. Okay. The applicant's case is that he needs to have his gallstones removed.
Your Lordship, letter 13 January 2025, medical.
Besides the applicant suffering from fatty liver. In this regard, he has relied upon the order dated
Your Lordship, no, on 13 January, I have submitted the report of the medical board, Your Lordship, where it states that he needs a surgery and it's not available in district hospital.
In
So
this
you need to take
regard,
out-
Ms. Livika had submitted. Where is that medical report?
13 January, I have already submitted it. In the last date.
We have got 1/12/2026.
13
This one, madam, this one.
medical board.
This is medical board report. 12/1/2026.
Yes, Your Lordship.
Has submitted. Letter number MS/DHD/PNJ/2021/984. Dated 12/1/2026, issued by the Medical Superintendent, District Hospital, Dimapur. With regard to the medical board report of the applicant, which states as follows. Okay. Next. The above letter dated 12/1/2026 shows that the applicant has been advised to have laparoscopy surgery for removal of his gallstones. And as such, we are of the view that because of a medical emergency, the applicant should be released on bail to enable him to undergo. He's Naga, no? There's no question of.
There is no laparoscopic in district hospital, so.
I know, he'll have to go.
Yes.
He'll have to go. Where in
Think
Dimapur?
referral is available.
Huh?
Referral is available. Referral hospital.
Airport.
Nearby
Wherever he'll do it.
Yes.
Wherever I said. On medical grounds to undergo laparoscopic surgery in any other hospital in Dimapur, where laparoscopic surgery is available. Accordingly, first up, though we prima facie find that the evidence. No, forget that. We won't mention that. Accordingly, the applicant is released on a bail bond or released on bail on a bail bond of rupees.
Trial court records have come.
5,000.
Trial court
What?
records.
No, too little.
Maybe 10,000.
No, too little. 50. 30,000 with one surety of like amount to the satisfaction of the learned trial court. The applicant shall be released on a bail for a period of 30 days only from the date of his release from jail. And he shall report and he shall immediately take steps for having laparoscopic surgery done for removal of his gallstones. The applicant shall thereafter surrender himself before the concerned jail authorities on the 30th, on the 31st day. On the 31st day. For incarceration. Consequently, the sentence imposed upon the applicant pursuant to the impugned judgment and order dated so and so, passed in so and so, shall remain suspended for a period of 30 days only, from to be counted with effect from the date of his release from jail. I is accordingly disposed of.
The main case of the paper book.
Paper book is to be made.
Not yet, Lordship.
Okay, right. And in the main case, as the TCR has arrived, registry to prepare the paper book. List the matter on after 4 weeks, after 1 month, give a date. 11th March.
For orders, item number 14.
The petitioner, he died on 29 December.
So?
To let the wife be bringing us legal representative.
He died when? 29 December.
December. In fact, 21st January.
He died 29 December. Then you have to file an application for imprisonment, no?
My lord, let the federal proceeding be by legal representative. That is the one.
Why don't you file an application?
My lord, I can do that.
Any objection to the delay?
Lordship, in fact, the state has preferred the written appeal. Lordship.
Oh, yeah.
Lordship.
Yes. Any objection to the delay?
My lord, it appears that there is no explanation to that effect.
You have got to be clear. What do you want? You want imprisonment?
My lord, what I'm saying is, let it be through the legal representative.
Okay, that's what we will do. But
yes.
But then there has to be an application anyway. We will do that. But do you have any objection to the delay being condoned?
My lord, yes.
You have got.
I will file a.
Then we have also got an objection to your application. Verbal application. You file a written application.
I will do that, man.
Have you got any objection to his to the imprisonment of the wife?
Lordship, in fact.
But we don't know who's the wife also, na?
Lordship. This.
My lord, what happened is this. It was when I informed the party about the decision in their favor, I was told that the person died. So I instructed them to obtain death certificate in the succession certificate. Then only the application was brought up before the department.
Okay, what we will do is we'll issue notice on the thing, on the coordination delay. You, while making your written objection, you mention all this. Okay? Right. Heard, Mr. Vizimomi, learned counsel for the applicant who submits that there is a delay of 277 days in filing the appeal against the impugned judgment passed by the learned single judge. Issue notice to the respondent. Mr.
IMT Longchamp.
IMT Longchamp appears for the respondent.
My lord,
and sole respondent and submits that the sole respondent has expired on 29/12/24.
Yes.
29/12/24.
24.
24. Then you should have mentioned to the court.
My lord, that is what exactly I am saying. What happened is that after getting the judgment when we inform.
29th of 24.
Yes.
And as such, he would like to file an application for substitution of the respondent by his wife, substitution of the respondent by his wife. Full stop. He would also like to file written objection to the application for condonation of delay.
My lord.
Full stop. The prayer of the respondent's counsel is allowed. List the matter after a month.
2 weeks.
After 2 weeks. When will you file a wakalatnama? Acha, with the application. You file all the application. This is the matter after 2 weeks. Okay.
For orders, item numbers
15.
15 and 16.
Any objection, madam?
No, Your Lordship,
No.
the informant has to be implicated.
Yes. Okay, right. Heard Mr. Moimchid.
Jamir.
No, Moa Jamir. Learned counsel for this. Who is this Grace E. Namgi?
My associate lord.
Okay. Moa Jamir, learned counsel for the applicant who submits that the guardian of the victim should be impleaded as the respondent number 2. As the father of the victim has expired in the meantime.
Lord.
Ms. Livika, PP submits that she has got no objection to the same. Accordingly, who is this person?
Mother of the victim, Lord.
Accordingly, what is her name?
Wilson Naro.
Accordingly, Srimati Temjen Naro.
Temjen Naro.
Temjen Naro, wife of
Mother of the victim, Lord.
that's all. Okay, wife of, it has to be wife of, nah. What is the father's name?
Not well. No.
You are appearing for whom?
I'm for the accused, Lord.
So what is the father's name? How do we know her address also?
Lord, it was there in the record, Lord. She was examined as one of the witnesses, Lord.
Which one? Let's see. And let us see the judgment then.
Page number 55, Lord. This is a statement under section 161.
161 is no use. 161 is only for contradicting
Lordship.
the evidence.
He was also examined as BW3, Lordship, page number 73, Lordship.
What about 53? 73?
73, Lord.
73.
Husband's name is written there, Lord.
Okay. But you should have put it in your application.
Lordship, I will, Lordship.
Temjen Naro, wife of. Is it father's name or husband's name?
Husband's name, Lordship.
Are you sure?
Lord.
How do you know? It says father/husband.
Lordship, it appeared from the record that the husband passed away, Lordship, and the husband's name was Shikato, Lordship.
Okay. Wife of Shikato.
Lordship.
Wife of late Shikato.
Lordship.
Resident of house number 58, Unity Village, Dimapur. So, what have I said? What have I said? The last sentence? So is the pleader, that's point number 2. Then applicant to submit a corrected copy of the cost title to the registry.
Lordship.
Okay.
Lordship.
Then in the main appeal, you write, in view of the order dated 11/2/2026 passed in IA Criminal 9 of 2026, so and so Temjen Naro, so and so, wife of so and so, is impleaded as respondent number 2. Issue notice to the respondent number 2. Accordingly, the appellant shall submit a soft copy of the appeal to the office of the PP
Lordship.
Comma, who shall furnish the same to the OC of,
Mr. Jen.
no, which police station? WNPS. WN police station. Full stop. The OC shall thereafter submit the same to the respondent number 2, shall furnish the same to respondent number 2 and give a report of service thereafter. This is the matter after 4 weeks. Has
Lordship, it can be to the jailer because it's.
no.
No. It has to be
It
sent
has-
to the mother.
No, not to the accused. It has to be given to that victim's, to the victim's mother.
Yeah, to the victim's mother.
If the victim's mother will be in the village, no, will not be in jail.
For hearing, item number 20.
What is this application?
My lord, this is appeal.
Or disposed of? Appeal under 302 Arms Act.
302, 307, 396.
How long will you take?
I may take 1 hour because they are murder case, life imprisonment.
1 person?
2.
2 persons?
2 persons.
Any eyewitness?
The thing is, the allegation is that we had used pistol.
How you had?
Pistol, arms. No exhibition.
Not exhibited.
No exhibition. Never sent for ballistic test. That is my whole case. I have just.
So the victim who died.
Yes.
How many persons died? One?
One.
Two? 1 person?
1 person.
So was there any comparison of the bullet? Was any bullet recovered from the body of the?
Nothing. That is the case. Bullet was never recovered. If we go by evidence, then arm was seized but never exhibited, never sent for ballistic.
So died due to what reason?
No, what does the postmortem say?
Postmortem says that died of some blood injury, bullet. Doctor said bullet.
Doctor said bullet.
Yes. So now in the absence
But
of
bullet not recovered.
bullet not recovered, pistol seized, not exhibited. Then where is the case of prosecution then? Initially, my lord, here I'm the amicus curiae.
But
State has appointed me amicus. So I'm assisting the court.
so the cause of death is the bullet. Let us see the medical report.
My
Yes, my lord. Before going deeper into the case, the questions of mentability, I'm a little bit uncomfortable with the affidavit still. Page 8.
Page 8? Affidavit? Page 8?
Yes.
Yes.
Now, the accused, the convict is behind jail, and he has sworn affidavit from Kohima.
How does it matter?
Whether this can be taken into account.
No, we're not on that. We're on the legality or the correctness of the trial court record. That's all. The trial court decision. That's all. Whether the trial court, how does this matter? You see, this affidavit has been submitted. Something. How does it matter? This is not a writ petition or something. This is only a case of an appeal, challenging the correctness of the decision of the learned trial court. That's all. So this appeal is filed by 2 persons.
Yes,
By the
yes,
two.
my lord.
So let us see the medical report.
My lord, the depositions of doctor.
No, where's the post-mortem report?
We were not provided because I'm putting at my case. Record was called.
Record was called. Is record here?
Yes,
Record here.
Yes.
So paper book has not been made, or what? But paper book is here.
Paper book is, but that is not part of the paper book.
Okay, that's not part of it. Okay, let us see the. We'll have to see that. So yes, Mr. Kaushal, how did the victims die?
This type of
Bullet.
gunshot.
Gunshot.
Yes.
Any bullet recovered from the body of the victim?
No, here the convict himself admitted that accidentally the bullet went off from his possessions. And it was seized from the convict himself. So the question of
He confessed to whom?
Under 313 also in conversation with the court.
313 is not, cannot be used for conviction. Supreme Court judgment is there.
But under 313 also.
No, 313 cannot be used for
I understand
conviction.
that, but he has voluntarily stated that.
He confessed before the trial court.
Yes.
Or he confessed before the magistrate.
Yes. I'm not magistrate. Magistrate, there's no record, but before the
trial court.
Yes.
And during evidence.
Yes.
During evidence.
Yes.
Where? How come he's a how did he confess? Was he a witness?
No.
164 statement is there.
No. Only 313. That my friends.
Let us see, show us. There's no case then.
Yes, page 61. Just check. Page 61.
But they have not put it in the
Paper book. Page 61.
My lord, this is 313.
In the 313 anyway, yes.
313.
Yes.
313 cannot be the basis for. Let us see the judgment, impugned judgment. What does it say? Page. End of the matter.
My lord will see the reasons and finding. 123. Start from 123. This kind of show me. Page 123, running page 123. Reasons and findings.
No, it seems that there are some witnesses, so witnesses' statement has to be there.
There.
Then?
Well, no, out of 14 witnesses, altogether 14 PWs, 13 were examined.
So?
None of them have pointed at me or Borofa that we have triggered the arms. And no arm was recovered but not exhibited. Arm was not exhibited. No one has finger point at us that I had tried. Lordship will see here, appreciate. Three things, three important evidence are here. One is the handyman who accompanied the driver, the victim. 2, first IO. 3, second IO. If we go through all the evidence, that it is clear that there is no evidence to show that the two accused who are in jail for 10 years, they have not committed any crime.
We will have to see the evidence.
My lord, all the evidence are reproduced in the judgment itself. Reproduced in the judgment itself.
Reproduced.
My lord. Page, isn't it?
It will be there in the paper book also.
Page coming from a handyman who was accompanying the driver.
Let us see the paper book. Is it, I mean, it is here.
Paper book?
It is here.
Page 34.
No. Let us start from the beginning. Let us see. What are the names of the appellants? Nongpong, Konyak, and who is the other one? Huh?
Nampai and Nongpong.
Nampai and Nongpong.
Nampai and Nongpong.
Charge sheet. Charge with two heads.
Trial court has taken the pain to reproduce all the evidences in the judgment.
Very good. It will help us.
Yeah, that will help us. Once we read the judgment, we come to know all the evidences.
No. This PW1, who is he?
The initial IO. From there also, Lordship will come to know the evidence if there's any against me. Whether I really triggered the arms, whether his arm was seized.
What is this? I personally saw and inspected the dead body. So as per my assumption, page 21. The victim helper told me. This police, no?
Police.
Police to know. Forget police for the time being. He says.
Yes, ma'am.
The victim helper told me. So he's not an eyewitness.
No.
So who is this victim helper?
My lord, page 37. Page 34.
What is his name?
Page 34. He's the handyman who was with the deceased.
The victim helper.
Page 34. PW13 Mohit Konwar. He was there throughout when the unfortunate incident happened. He was the only eyewitness.
Who?
This PW13.
13, page 34.
Page 34. He was the handyman. The driver, allegedly driver was shot that when he was there.
Page 34 is not.
At the bottom, at the bottom.
Oh, okay.
You have to tell the registry. Different page, different eyewitness.
This one is actually part of the.
Ah.
At least against the two appellants, no evidence as per the depositions of PW13 also went on. Altogether, there were 5 accused persons initially. But by this impugned judgment.
No, come to page 35.
Yes. Page 35, my lord.
Bottom.
My lord. As we were in the process scuffle, the accused fired his gun upon me for the second time and it hit me on the right arm. After down to the stream, I crossed the stream and ran to the safe distance and I tried to ascertain the movement and the activities of the accused person. My lord, there were 5 accused persons here. 5 accused. No one has identified my name. 5 accused persons. That's the thing. That's what I'm.
Okay, so they have not identified you by name. But they don't know you, but they might have identified you in the court. That person.
No. When this man was examined before the trial court, I was present. His statement said that the one who shot me is not present today. Last part of this, my lord, on the same page 36, down last sentence, from the last sentence 3. I identify the photograph exhibit produced before me as exhibit P7. I can identify this all of the accused person present in the court today, merely Nongkong, Yankai, and Taiman. So come to cross-examination, my lord. Next page. Cross-examination 5.
So Nongkong is there.
Yes.
Then who's the other person? Yakai.
The Nang Pai. My lord, come next page, cross-examination. What did he say? Cross-examination 5. It is correct to say that the accused person who shot me is not present in the court. I was present in the court. Out of 5, I was present in the court. He said,
What is your name?
My name is Nang Kong. No Kong.
But no, he has identified you here.
No, my lord lordship will see. I was present in the court. He said, yes, no people are here. But the one who shot me was not present.
No, he said here, Nongkong. He's in the thing.
Lordship, correct.
But then you see, you see, in a criminal proceeding, there are always some discrepancies. Some discrepancies, supposing they say black in the examination in chief, sometimes they say white because of the questioning, the manner in which questioning is done. So unless it goes to the root of the matter, then that can be overlooked.
No problem. I understand. Because we need legal
No criminal proceedings or criminal investigation is 100% proof. Safe. It's not 100% safe. There is always usually something or the other missing, but that has to be overlooked at times. Otherwise, you'll never have a conviction.
At least in examining chief, he said, yes, these two are present, but in cross, the one who shot me is not present today. So out of 5, only 2 were produced before the court when he was summoned to be a witness. That is the point. Now, lordship will appreciate here. Yes, my lord. So therefore, I was present in the court when he was produced. He said, yes, he said, but cross, he said, the one who shot me was not present today.
Then again, he said it is correct to say that the one who hired the vehicle shot the deceased driver.
Yes, I did not hire. Out of 5, I did not hire at all. So therefore, in fact, yes, we admit trial court, a different young people have conducted. Now before this court, when I checked all the evidences, there's no evidence against these 2 to convict for life, let alone for life. Now they're in jail for 10 years.
I think we have to go.
No doubt, we need detailed hearing, no problem.
I think it'll take some time.
No problem. I'll take, I'll take 1 hour. I'll do that. Because there's no evidence. So therefore, I want to do justice as amicus.
It'll adjourn the matter.
The allegation is that I shot them out of 5, 1 shot them. No, arm was allegedly seized. No exhibition. Bullet was not.
You're convicted for how long? Sentenced to
life. So only his 2 dead body will come out from the jail in dead case.
No, but he has been identified. He has been identified here.
Lord, my lord, see.
But of course, name is not given again. There are 5 accused persons.
5 accused persons.
So 3 were discharged.
Yes. By this judgment. How can, on what basis? That's what I want to explain everything.
Who has shot?
Who has shot? No witness has identified who had shot. And that's why I have a lot of judgment to satisfy the court.
Like it's very clear. The one who hired vehicle is not the Yokong, the other co-convict. He is the second appellant here. He hired the vehicle and
Who
he
hired?
shot.
Oh, this Yekai.
Yes,
Two
Yang Pai.
person hired. 2 person, not me. 2 person hired.
It's very clear. Yes, but the name is Yang Pai is very clear. And he himself admitted in 313, that is, this one was considered admissible. He himself said that the gun was.
You see, 313, explanations given under 313 can only be used to corroborate.
Yes, I'm just corroborating, my lord.
It corroborate evidence.
Yes, that
The
he
way-
himself say that the gun was the fire, the bullet went off from his gun, which it was seized, though it may not be produced.
Ye Khai said, Ye Khai said.
Yes, Yang Pai.
Yampai.
So as far as evidence against Yang Pai is circumstantially very clear. Though the other, to be honest, as far as Nok Hong, to be honest, he may have involved, but doubt may arise. But as far as Yang Pai is very clear.
There is no evidence to show that arm was seized from me or from Yang Pai. No evidence at all.
No,
I want
but
to satisfy the court.
To corroborate the evidence, he
No,
himself.
maybe, but then you see, it doesn't matter. If there are eyewitnesses to a crime,
That is the thing.
there is no requirement of the weapon requiring to be seized.
The eyewitness is the handyman who had deposed PW13. He said, I didn't know what type of arm was used. I didn't know who shoot it.
Naturally, some persons will not know. You don't expect everyone to be a gun expert.
Correct. But my lordship, my submission is correct. But subsequently, arm was seized. That was not exhibited. That's the problem. I have judgment to show, my lord.
No, it's okay. FSL report also, if it's not sent for FSL examination, but then when the admission is there from the horse's mouth, so why should we disbelieve?
No, cannot, because unless there is some substantial evidence to prove, to corroborate, how can we? The lordship has read. I have judgment. How can court believe entirely on the statement on the 313?
No, 313 along with that PW13 who said that he was killed by the one who hired the vehicle.
That's correct. So you see, two person hired. Who is that man? 2 person hired from Sonare. Who is that man? Only one fellow shot. Only one fellow triggered the bullet. Who shot that? Is there any evidence to prove that Mr. A or B has shot out of 5? So there's no. That's why I'm very confident. There's no evidence at all to convict these 2. I'm quite confident. At least this case, I'm confident about.
Lawyers are always confident.
No, please say no. I have gone to the out of 13 PWs I have gone through. No one has been pointed to either of these 2 out of 5. 2 persons hired a vehicle from Sonare. Then one fellow allegedly one fellow triggered, but no one has pointed Mr. A, Mr. B. Even there's no evidence at all. Otherwise, we are all for the justice, no doubt. So if we read through all the evidences from 1 to 13, I want to satisfy the court. And after that, we want to read the judgment, whether the judgment is perverse or not, whether judgment was pronounced against me without any evidence or not. I want to satisfy them.
You are ready?
If you are sitting, then we can have a opinion.
I think we'll adjourn this matter.
No problem. We need proper hearing. I'm also convinced. I'm convinced about that. Because I must satisfy that court also. Taking all the evidences.
Will this matter in the next week?
Lordship, in next after 2 weeks, Lordship.
Right. On the prayer of the parties, this is the matter after 2 weeks.
Like,
For hearing item number 21.
Problem, no, when 2 of them. Actually, there are not.
Maybe these lordships.
The evidence was not done well. They did not mention who has done. Yes.
The Lordships, my learned friend and I, we have a consensus opinion. We have arrived to a consensus and would like to pray before your Lordships whether this matter can be taken up after a week. So it will take some time. This is also a murder case, my lord.
Eyewitness?
My lord.
Any eyewitness?
Your Lordship, there is only no direct eyewitness, Your Lordship. The only person whose statement matters is an interested party who was made an approval without following the due procedures of law. That is PW6. She was arrested as an accomplice. Then later on, she was made an approval without following the due procedures of law. The rest, the other witnesses, Your Lordship, none of them are of material witness. Not even a single sterling witness, Your Lordship, in this case.
Okay, we'll see. On the prayer of the parties, list the matter after we.
My lord. Lord, Your Lordships.
For hearing, item number 22.
20? 23, I think.
22.
22.
Lordships, Lordships, I'm going to complain here.
You're going to complain?
Complainant.
Yeah, informant, you mean?
Informant, yes.
You cannot be a complainant. In a criminal, in this case, you are an informant.
Informant.
Yes. What?
My lord, unfortunately, I did not bring the bill.
It's okay, you don't have to bring, he's here. Your informant has got hardly any role to play. Just go and support that. Sit down. We'll hear him.
My lord, in that case, during the break, if I may, be kindly allowed to go through the court's file, my lord.
Ah, sure. You're not brought your records. Why?
Since yesterday, we have been searching even the disposed file, my lord, but we are
Okay.
able to locate it by today's and last. I don't know how it happened. Otherwise, Lordship.
Well, what is the evidence of the victim?
Lordship, there are so many lacunas, Lordship. Firstly, 313 is not been properly conducted. Incriminating circumstances have not been put to me, my lord. Secondly, my lord, the victim is claiming that a spray was used so that she would faint and that the accused will commit those sexual offences upon her. Now, my lord, there is no such spray known till today, my lord. Where it will be sprayed upon an elder person.
How old is the girl?
12 years, my lord. 12 years. Lordship, and my lord.
What do you do? He does not have a.
But
some part of the trial was also conducted before my Lord Justice Royal Lankuman.
How does it matter? She did not pass the
I
final
didn't
order.
pass judgment, no?
Well,
my case is that, my lord, the foundational facts have not been proved, my lord. By the
well, you see, the entire thing rests upon the prosecutrix.
My lord.
If the prosecutrix evidence does not inspire the confidence of the court, then we can seek corroboration. But if it inspires the confidence of the court, then we don't need any other evidence. Then that's the law.
That's what I'm saying, my lord. My lord.
Let us see which page is the evidence.
Lordship, in order to shift the burden from the prosecution to the accused, my lord, the foundational facts have to be proved by the prosecution first.
So let us see. So that is what, let us see. That is what you are saying.
Yes,
whether what you are saying is accepted or not is a different issue.
Lordship.
Correct. So we'll see that. Let me see. My name is Monu Ghosh. I am the complainant. Rape of my daughter. My name is Ben Thompson. Then let's see. Where is the victim? Victim is Tana Ghosh.
Yes, Lordship.
Kiran Ghosh is the thing, no? Yes. Kiran Ghosh is the maid. Let us see her evidence. Yes, page 90. So she became pregnant. She was pregnant.
Yes, Lordship, that is.
Does she have a child?
No, my lord, the child was never produced, and they are saying that the baby is gone now.
Where's the baby? You see, it's very simple. Whenever there is a, even during investigation, a DNA profiling test can be done. So if the victim has a child, what we do is we do the profiling, DNA profiling of the baby. We can do it now. Doesn't mean that just because it was not done.
Lord, in the prosecution's case, that is what I'm pointing out, my lord. The baby is gone. They are saying that the baby is not with them.
Not with them.
Yes, it was adopted by somebody else. They are saying that.
So whatever, they'll pick up some baby from somewhere.
The baby
Then
is released from the prosecution story.
They'll pick up some baby from somewhere. If it is does not then if it is not yours, then it will not match. If it is yours, then it will match.
My lord,
Correct. So if it's not yours, then it will not match. Even if they pick up from wherever, Egypt or whatever, it will not match. So does the victim have the baby? You find out during lunch. Just call the thing.
The IO will know.
IO will know. If the baby is there, we will direct that DNA profiling be done of you and then the only thing is that the report. The report will clearly show whether you're the father or not. If you're not the father, finish, end of the story. Maybe the end of the story, may not be. Because there is no evidence to show that something happened while she was unconscious or something like that. We do not know. Because anyway, the first thing is that once it is clear that he is not the father, that means some other person was involved. But if it matches, then
Yes, my lord. There is plenty evidence.
end of the matter.
My lord.
At 2? 2 o'clock. Any other matter we've got for this? Two more. Acha, I've got one matter with Justice Mr. Akito.
My lord.
So single bench matter. We'll take it up at 2. It'll take 5 minutes. Then we'll carry on with the DB. Could you just tell Mr. Akito you want me to take up that? Yes, you're there. We'll take it up at 2 o'clock. Oh, you're ready. You're ready. Now we can take it up now also. You can call Mr. Akito, then we'll take up the division bench at 2. I'll just come again for that single bench matter. What is this paper book? Having the lapel. Family Courts Act?
Yes, ma'am. Okay. Yeah, you have a copy of the Family Courts Act? May I read the section 19, repeat. Same as provided in subsection 2, and notwithstanding anything retained in the Code of Civil Procedure 1908, or in the Code of Criminal Procedure 1973, or in any other law, an appeal shall lie from every judgment or order, not being an interlocutory order of a family court to the High Court, both in facts and in law. So the order which I am challenging is an interlocutory order.
No, but then then you cannot file a WPC. There's no ground for filing a WPC.
This is Article 27, ma'am.
No, 227. It's only on jurisdiction that you can challenge. Now, what is what has it assumed a jurisdiction that it does not have?
No, madam, that's not the point. So what I'm saying, my repetition is the learned family court has ignored fundamental principles of law in arriving at this decision. And on this point, Your Worship, there is a judgment of one of the Supreme Court by a 3-judge bench, and a judgment authored by none other than the former Chief Justice of the Gauhati High Court, Justice Sandeep. Same point.
Which one? Digant?
Alati Ramachandran.
Yes.
Can you go straight to paragraph 7?
7. Yes.
On 22nd July, the respondent father filed an application bearing IL number 2 of seeking interim custody visitation rights for children in the custody proceedings issued by the parent mother. The family court, by order dated 7/10/24, granted visitation rights to the respondent father, permitting him to visit and interact with children from 10 a.m. to 1:30 p.m. on the second Saturday of every month at the court premises. Respondent father was permitted to interact with children via video calls from 7 p.m. to 7:30 p.m. on all Saturdays except second Saturday. On the next paragraph, on 8 November, the respondent father preferred an original petition under Article 227. So this is against the interlocutory order of the Constitution of India, bearing OP numbers and such before the High Court of Kerala. The said petition came to be decided by the division bench by order dated 11 December 2024, providing interim custody for the children to the respondent father, the terms indicated below. So the terms were indicated, Your Lordship. And then it can come now, Your Lordship, to paragraph.
Just a minute.
Can we go to the terms, Your Lordship?
Just a minute. Terms, yes.
So paragraph 8. Considering the fact that father also needs the custody of his children, we have bonding with them till the 18th age of 18 years, we will not keep the father away from the internal custody of the children, as the children require the care and custody of both his spouse's parents. Accordingly, we grant 15 days of custody to each in a month till the disposal of the OP pertaining to permanent custody with the following divisions. 1. Husband shall file an undertaking regarding taking of the flat on death bearing number and such, which is fully furnished as well with regard to the engagement of a nanny within a period of 1 week from today. 2. He will also make arrangement of the vehicle for commutation of the children for drop on and drop off, that is to and from the flat and the school or another place. He will not take the children away to Thrissur. He is at liberty to bring his mother to Trivandrum without the permission of this court. He will ensure that the children are taken care, healthy and congenial environment, and there is no lacking in it. We have been informed that every year there are summer vacations in the school from the end of March, entire April and May, and the school reopens on 1st of June. The similar arrangement will go on during the said period also. However, it's very clear that whenever there is examination, the custody of the children will be with the mother only, and the custody will be given 2 weeks prior to the examination. The mother will give advance information to the husband either through WhatsApp message or through any other mode regarding the examination. 11. During the period when the children are in the custody of the husband father will permit 15 minutes of video call every day to the mother. This arrangement will also be carried out by the wife mother when the children will be in the custody of the mother. In any case, in case of any violation, the liberty is granted to either the parties to move an application, petition a husband. Father is also directed to undertake parental counseling. Right? Next paragraph. The appellant mother has approached this court to risk appeal by special leave The sailing is set order of the High Court granting periodically interim custody of both the children to the respondent father. Now, if you can go to the directions map,
Yes,
paragraph 19.
yes,
You know, got paragraph 19.
yes,
There are a series of judgments by this court wherein it has been authoritatively held that in cases of joint custody, the paramount consideration should be the welfare of the child. The utmost sincerity, love, and affection shown by either of the parents by itself cannot be a ground to decide the custody of a child. 20. Keeping in view the aforesaid principles and aversion to the facts of the case at hand, we feel that the interim arrangement as charted out by the High Court in the imperial order granting 15 days alternative custody of both the children to their parents is neither feasible nor conducive to the well-being, mental and physical of children. The younger of the two children, being the son, aged about 3 years, has hardly lived with his father, but lives and works in Singapore, thus directing the custody of the intended age point to be assigned to the respondent father, even on an interim basis for a period of 15 days each month, is grossly unjustified, and may have serious adverse effects of the emotional and physical well-being of the child, and may create a sense of deep insecurity in the boy going to forced separation from the mother. The interim arrangement made by the High Court to the extent of the 3-year-old son is totally uncalled for and unsustainable on the face of the record and is hereby set aside. This is in respect of the 3-year-old boy. And in respect of the other child also, Your Worship, at the beginning of paragraph 26.
yes,
Paragraph 26.
yes,
In this background, we feel that the High Court clearly erred in granting interim custody of a children to the respondent father for a period of 15 days every month. The arrangement made by the High Court was not arrived at by weighing the pros and cons of the situation. The periodic division of custody is definitely adverse to the well-being, physical, mental, and emotional of the children. In the long run, this arrangement may prove extremely harmful and cause irreversible mental trauma to both children. Hence, we are of the firm view that the improved order passed by the High Court granting interim custody of the children to the respondent father for a period of 15 days every month is unsustainable on the face of the record. However, at the same time, we cannot lose sight of the fact that the respondent is a doting father who has shown his keen desire to have an equal and effective parenting role in the upbringing of his children. Thus, depriving him of the custody of his children in entirety is neither acceptable nor justifiable and will destroy all chances of family bonding. 29. Hence, in order to provide the respondent father fair and reasonable access to the children, we hereby direct that he should be entitled to interim custody of the daughter. So this is the elder daughter now, only the daughter. On alternate Saturdays and Sundays of every month. On either of these 2 days, the respondent father will be entitled to meet and have interim custody of the boy child for a period of 4 hours for the 3-year-old son. For 4 hours, subject to the comfort of the child. This period of 4 hours interim custody of the boy shall be supervised by a child counselor who is to be engaged by the respondent father with prior approval of the family court. The respondent father may either retain the same flat or take. So this is the direction of it. So even for the interim custody, it has to be supervised custody. A counselor has to be present. That is why in my petition, I have also made the concerned department of parties. There is not much information in the public domain as to if there are any qualified counselors in the state.
Where's the impugned order? Page?
It's 34. Page 19, beginning to page 19. And the visitation is at page 34. Visitation schedule is at page 34. And the other point which I would like to raise with your lordship, I know that page 32, paragraph 28, the order, the order. The this interim visitation schedule is made effective from the date of passing of this order. It is 3/11/25 till January 26. So even the period is not over now. So what remains is now the new terms of visitation.
So this order basically is finished. The validity period has gone.
Yes. So the family court now has to decide again on the new terms of visitation.
So the entire issue has been, there's nothing to decide.
Yes, no. As of now.
No, my lord, the only objection which the raised was the overnight visitation. It is only what you can decide on the point.
And the
And this is for visitation schedule.
yes.
It's only visitation.
Yes.
The one night, that portion is overnight has not been decided.
That was stayed, my lord. The visitation was not stayed. Only the overnight visitation was stayed by the Supreme Court. And both visitation as well as overnight stay is now gone. And this is the
Overnight has not gone. Only visitation has gone.
no, your lordship. If you, my lord, you can't click on page paragraph 28 again. The interim visitation schedule is being effective from the date of passing of the order till that is 3/11/25 till January 26, or till an arrangement is made, is right there between the parties, whichever is ready.
So only visitation, right? Overnight has not been touched.
Visitation, if your lordship will kindly to the 34th.
34.
So visitation includes both the visitation as well as overnight stay.
Overnight visits, my lord. 29/11/2025 to 01/12/2024. 2 nights and 3 days.
Daytime visit, overnight visits. Daytime. So this is the visitation right. It includes here. So basically this order has now basically the validity has expired. So it has to take a fresh decision.
Yes, ma'am.
Or my lord, if the point on overnight visitation can be decided.
No, I would, why should I decide? Let you all go back to this thing and decide that.
But once overnight visitation is granted, then it will come of the king overnight.
That would happen.
Yes, my lord.
Just let me see the judgment.
Oh, my lord, my humble submission is that while deciding custody cases, this honorable court is not bounded by precedents.
No, that's not. That's correct. It depends on the facts and circumstances of each case.
And this the Honorable Supreme Court also has granted overnight custody to their father, 3.5 years old. I have said this is upon my case. Yes, please. Well, I marked the relevant portion. What education was given and therefore exactly my case, my lord. On Friday night after school.
Two judges by
Yes, two judges.
No, but then still these are the
No,
facts
this
of
is
the
also
case.
two judges, my lord.
No, there's three judges. There's three judges.
My lord, but the prisoners will not bound this court while they sit in custody case.
No, but
It is
we
unique.
uh,
So
correct.
case is unique.
No, a decision is an authority for what it decides. And a little difference in facts changes.
Yes, my lord. And I'm not asking for 15 days overnight custody and these things. I'm just seeking for once in a month.
Your Lordship, since this,
No, you see, right now the case is basically an appeal by him.
Yes, ma'am.
I mean, it's a writ petition by him.
Yes, ma'am.
If he withdraws, then the entire case goes on the ground that this visitation right is now has become now become invalid. Then there's nothing to decide.
But my lord, the point of overnight visitation.
But then the issue here is basically with regard to the legality of the order.
They are mainly agreed by the overnight visitation, my lord. And this only for the state, only on that point, that overnight visitation will not be allowed.
I want, if I may, since the order has now expired,
Yes.
let the parties go again before the family court, let the family court decide. And not only as parents, but taking into account all the attending circumstances, let the family court decide.
Correct. So you withdraw this writ petition with and you both go there.
Very well.
Withdraw this writ petition, saying that it has become invalid. The challenge is no longer required because it become invalid. Right. Heard Mr. A. Momi, learned counsel for the petitioner, and Mr.
Yes, okay.
S. Sophie,
Yes, sir.
learned counsel for the respondent number two. Respondent number two. One. Miss Divika appears for respondent number two. The petitioner has put to challenge the order dated 3/11/2025, passed by the learned Principal Judge Family Court, Kohima, Nagaland, in IAC number 5 of 2025, arising out of custody case number 1 of 2025. The learned Family Court has, by the impugned order, modified the visitation rights granted to the respondent number 1 with regard to his minor daughter who is 3 years.
3.5 years.
Who's 3.5 years?
Yes, and 7 months.
Who's 3 years, 7 months. Wherein he has allowed the respondent number 1 to take his daughter home for overnight stay. First up. The interim visitation schedule made by the learned family court, which includes overnight stay, was made effective from 3/11/2025 till January 2026, or till an arrangement was arrived at between the parties, whichever was earlier. First up. Next para. Mr. A. Momi, learned counsel for the petitioner, submits that as the validity period of the interim visitation schedule provided in the impugned order dated 3/11/2025 has expired, he would like to withdraw the writ petition, and any claim for visitation rights or overnight stay by the respondent number 1 should be decided afresh by the learned family court. The counsel for the respondent, on the other hand, what do you say? Submit that as the interim visitation schedule has which is provided in the impugned order dated 3/11/2025 has expired, the then a trial court would have to, then a family court would have to decide the issue afresh. This para. On considering the submissions made by the counsel for the parties, the present writ petition is dismissed as withdrawn, comma, with liberty being given to the parties to approach the learned family court again for taking a decision on the visitation schedule, including overnight stay. Prayers that may be made by the respondent number one, by the parties. The, that's all. Wait, I put this also, put this too. Give me this, I'll just keep this. Yes.
Lordship, I'd like to mention Arden is being part of the tribunal petition, bail number 2/2026.
Bail,
It's for the tribunal petition,
430 BNSS.
528. Yes. Arden is.
I don't know, and the DB, single bench. Single bench tomorrow. Not today.
The name is showing, na, Jimomi, and his name is Sophie.
Yeah.
S.
A Sophie.
A Sophie.
Yeah.
SOTHIE. A Sophie.
Item number 22.
Ah, yes.
In the morning,
Yes. So we were waiting for you.
this appellant is in jail and then he's 81 years of old now.
Oh.
81 years.
So
So
that doesn't make him innocent.
then, yes, according to the information from family this morning, he's 10 years ago he had a stroke, and then he is having high pressure, lifetime medicine, then diabetic patient. And now till today he's 81 years old. So he has served about 4 years in jail now. So now my
So this is under section 6.
Lordship, sections are section 4A 11. 4A 11.
I do not know why they have to go to 8 and 11. 11 is sexual assault. 8 is also something like sexual assault. And 4 is, of course, penetration.
Yes. 4 is for punishment for penetrative sexual assault. 4.
And when did this, so this incident occurred after the amendment?
Incident occurred on 28 July 2021.
You have not even completed, half the period. Let us see the evidence of the victim. What does she say? passed in your favor,
Yes,
in
sir.
favor of the wife.
Yes.
Then what happened? Then who died?
The wife died.
Then the wife died. Then now who are you?
I'm the sons,
The son.
by representative.
The son.
Yes.
So you are claiming what?
Pension for my
Under what rule?
Lordship, he was initially appointed as contingency paid Domashi for 3 years, and then he was
How old are you?
the petition
The
was
son.
Naturally, not you, not you. The son.
Lordship. I'm so sorry, Lordship. I think I will see. He's 55 years.
He's 55.
Yes.
That's fine. No, but he is asking. Okay. Okay, so your father retired from service when? Which year?
1982, Lordship.
1982. And died when?
In 2002. He died in 2002. However, he was
And the mother filed the writ petition when?
First it was filed in 2015. However, it was withdrawn and she filed a representation. And 2017, this writ petition was filed.
When your father died, in respect of your father's service in 1982,
Yes, sir.
he retired in 82, and writ petition filed after, my God, 33 years.
Yes. Lordship, since this is a petition for the
And you're 55, where is your right to? Your pension is under what? Under what provision?
it is not my right, but my mother's right. And it was decided by this honorable court that she has the right. And then
No,
after that,
did your father get pension?
No, my father.
That is what. If your father was getting pension and your mother didn't get, then it's okay. But your father never filed a petition. He retired in 82.
Yes.
He died when?
2002.
2002. Your mother filed a case in 2017 for pension. In 2017, after 33 years of the pension of your father. Your father never filed.
Yes, ma'am.
And then you are 55 years as on date. And pension is to be granted under what provision of law? What did the single bench say? Under the CCS 1972 rules, correct?
The issue there was with regard to counting my contingency paid term, which is 3 years.
How can you file a paper? There is a judgment of the division bench of this court.
Yes, sir, but that was after the writ.
Anyway, you are lucky he has asked for adjournment. I don't know. I don't know. Let us see the judgment. What has it said?
Judgment is at
Page.
95.
Who is the senior?
I implement it. Relevant page is at 109.
3 years, 10 months. He served for 3 years, 10 months.
No case. I mean, the appeal is there. Appeal okay.
Pension was denied on the ground that he did not complete the qualifying length of service.
You see, there is a limitation period for filing anything. Even a writ, though it does not have a limitation period per se, but the spirit of the Limitation Act will apply. And that is what has been decided in number of cases by the division bench of Gauhati, Supreme Court. And you're right on the prayer for adjournment made on behalf of the appellant's counsel. This is the matter. After 2 weeks. 2 weeks. Good, you're reading the case. Very good. Good. You should read. The huh? Who? Oh, okay. Oh, yeah. Imti Longchan is your father.
Yes, sir.
Okay. No, it's good. You should read. The more you read, the more it becomes easier to understand. Anyway,
Sai rồi biết. Tin tao của bạn này.